Welcome to another episode of Living Justice, Living Leadership. I'm your host, Lee Fisher, Dean of Cleveland Marshall College of Law at Cleveland State University. You know, I've had the great privilege to live my life at the intersection of the public, private, nonprofit, and academic worlds. As a lawyer, CEO of 2 nonprofit organizations, and as a state legislator, attorney general, and lieutenant governor. And the lessons I've learned come down to just 2 words: justice and leadership. That's why every week we'll talk to people who are walking the walk. Some are lawyers and some are not, but all of them have something in common. They are change makers. They are guardians of justice. They are living justice, and they are living leadership. In our last episode, we talked about your remarkable career from being a graduate of this great law school, Cleveland Marshall Law School, to being an attorney in private practice, magistrate, Summit County Probate Court, a judge, Summit County Court of Common Pleas, prosecuting attorney, being selected as the running mate for Bob Taft and defeating Lee Fisher for governor and lieutenant governor in 1998. And then in 2002, you were elected to the Ohio Supreme Court. Let's talk about that race for a second. Tell us about that election.
Well, 4 years were up, and I had to make a decision. Was I going to continue as lieutenant governor, or was it time for me to do something else? And in the back of my mind, I was always thinking I wanted to get back on the bench. And even when I was prosecuting attorney, I said to myself, I'm going to do this for maybe 3 terms, and then I want to go back to the common pleas court bench. And but other things came about, and I didn't do that. But so I thought, all right, here I am. What am I going to do now? And there was an opening on the Supreme Court because Andy Douglas needed to, he had to retire because of the fact that once you turn 70, you can't run again because you're constitutionally senile.
By the way, I think that's a bad rule and a bad law, but we can talk about that later.
Yeah, there's nothing we're going to do about that, but anyway, so there was this opening, and I thought to myself, I always wanted to get back on the bench, and here's an opportunity. And my perspective, having been in Columbus for 4 years, at that point, I really thought, well, this might be the path for me to get back into the judiciary, the judicial branch of government. And so, I think I had the credentials to do it, having been prosecuting attorney and a common pleas court judge, magistrate for almost 9 years. So I had a good, solid credentials. I was obviously the public safety was a good credential, and a lot of the other things that I had been doing. So I also had the political chops, as you were, because of my involvement on a statewide basis, and the trips that I had made to practically every county in the state in those 4 years. So anyway, I decided I was going to run to fill that seat, and I did, and I was elected, and I just was on the bench with just great people. I really immediately enjoyed it. Tom Moyer was the Chief Justice at the time.
Great man.
And, Tom passed away in 2010. He was just a delight to be part of his court. Alice Roby Resnick was there. Francis Sweeney.
Another graduate of Cleveland Marshall.
Yes. Paul Pfeiffer, Debbie Cook, Eve Stratton, me. Am I forgetting one? No, Tom Moyer. I didn't count.
That is quite a court. You're right.
Yeah, it was. It was a great court, and I just thought it was a great environment, interesting, job to do. You're reading the law, great people to work with, wonderful staff. It was great, and then, we moved into our building that we have now, which was Tom Moyer's vision. And in 2004, we moved into that building, March of 2004, which was, like your office is a palace.
Yes,
the building is magnificent.
If you've never been to this, it's got to be the most beautiful Supreme Court in the country, isn't it?
It's close. It's up there. It really
Okay.
is. In fact, at their dedication in May, we had Chief Justice Rehnquist come, and he was in awe of the building. I remember spending time with him and talking about the building. I was kind of chair of the dedication,
Mhm.
responsibilities for the building, and it was he was just in awe of the artwork. So if we're opening the building up again for folks to come in now. It's been closed to the public. So if you got time in the summer and you want to come in and take a look at the building and just walk around, it's the murals, the bronze, the marble, the artistry. You could never duplicate that building. But anyway, we had this magnificent building, a state of the art in so many ways, and yet it was from 1929 when it was started. So it's a great building. And then, uh, you know, uh, like any job that is dependent on elections, the public deciding whether you're going to be elected or not, and the mandatory retirement. Things change on a court. The
Mhm.
makeup of the court changes, and that happened to the Supreme Court. Um, and fast forward 6 years, because our terms obviously are 6 years, and I stand for reelection. And at that point, I was reelected, and I won every county in the state.
Mm. Not easy
Uh,
to do.
no, no, it was not. In fact, I remember that night, people kept saying, "How are you doing this?" And it's like, okay, I campaign. What can I say?
Right.
So anyway, I knew, that was a good thing to have done in 2008 because there was a Chief Justice race in 2010. Tom Moyer was, mandatory retirement, and that's when I began thinking about becoming Chief Justice. I did not enter the court thinking that I would, one day want to be Chief Justice. That's, just like I didn't become Lieutenant Governor thinking that I wanted to be on the court, or
Right.
enter being a prosecutor thinking I want to be, Lieutenant Governor. These are just opportunities that presented themselves, and I happened to be in the right place, the right time, with the right credentials and preparation. And I had, I think, built credibility for myself, which is a trait that you've got to have,
Yes.
and leadership, which is extremely important. There's that quote from Shakespeare that says, some people are born great, some people achieve greatness, and some people have greatness thrust upon them. Well, I use that when I talk about leadership. Some people are born leaders, some people achieve it, and then some people have it thrust upon them. And I think I'm all three,
Of course.
depending on what job I had or what opportunity presented itself, whether I achieved it by thinking it and working towards it and envisioning it, or whether it was kind of thrust upon you because the opportunity presented itself. But that's the way I look at it.
But because you had been so prepared, you took advantage of that opportunity that was thrust upon you. Had you not been prepared, you would not have been able to take advantage of it and win that election.
Absolutely.
Right?
And again, that's another thing I talk to students about. Grade students, high school, college, and law school. There's only one person that can stop your success, and that's you. If you do something that is going to derail your eligibility for the next opportunity that presents itself, that's on you. And so, watch what you do and be careful and make sure that that you work hard. And people, when they're thinking about, okay, we need somebody to do this job, and you'll pop in their mind because they've noticed the work you've done.
You've had very extensive agenda during your years as Chief Justice, ranging from racial fairness to conviction reform to bail reform. You've really made a big difference in technology and innovation. You've dealt with debtors' prisons and access to justice and judicial elections and the death penalty. The list goes on and on. And I think we want to get into some of these issues today. So you choose the one you want to start with in terms of some of the issues that you think have been most important, where you've been able to hopefully have some effect.
Well, let's start with fines, fees, and bail. That was an initiative, a task force that was set up on a national level by the Conference of Chief Justices and the Conference of State Court Administrators. And that was a task force that, again, was put together. Everybody that needed to be at the table was at the table on a national level. And, we created deliverables, is what, you call them, tools that can be utilized, policies that were developed, recommended, practices, model legislation, model regulations. And these were all tools to be disseminated to courts so they could embrace them, judges could be educated, and you'd realize the constitutional requirements when it comes to bail, when it comes to fines and fees, and how something as basic as an ability to pay hearing in the face of indigency, it was, not just mandatory, it was constitutional. You can't punish somebody for being poor, but philosophically and practically, that was what was being done in our country, in so many courts across our country, that a fine and a fee would be imposed regardless of your ability to pay. The defendant didn't have the ability to pay, that mushrooms into a contempt, that mushrooms into an arrest, another arrest. You're placed in jail if you've gotten a job. You may have 2 jobs, maybe 3 jobs. You lose those because you're in jail. You can't make bond, which is a whole nother thing, is who belongs in jail. So anyway, this was a national task force, and there was some great work product that came out of it. On the National Center for State Courts, which is a website, ncsc.org, there's a whole section devoted to the work product of the Fines, Fees, and Bail Task Force. And, I would recommend anybody taking a look at that, for this topic, because it really is instructive and is a great tool for learning. But, the outgrowth of that is, improvements to the bail system as well. And that's something that I've been, working on here in Ohio, how Ohio addresses bail. For the longest time, originally, bail was set up to get people out of jail. That was, and it wasn't monetary. You were being bailed to the custody of a family member, a neighbor, somebody who was going to vouch that they were going to get you back into, answer for whatever transgression you've been accused of. And it didn't involve money. So then it morphed in America to be a system of, you got to put up money. You've got
in other words, to keep you in jail.
And it turned out it morphed into a method to keep people in jail. And so the mentality of the public is, well, you set a high bond, so they're not going to get out. And think how ridiculous that sounds. If you're too dangerous to be out in the public because of something you're accused of, and there's good reason to believe that you committed that crime, and you're going to intimidate or injure the witnesses or the victim, and you're a danger of flight, or both, you don't get out of jail pending pretrial. You've got to. And then there's also other mechanisms. You can use ankle bracelets. You can do day reporting. You can do drug screening. You can do all kinds of things to make sure that the person who's out of jail pending the resolution of their case is staying clean and law-abiding. Mm-hmm. And there's so many reasons to do that. And if you don't believe in the constitutional reasons to do it, believe in the pocketbook reasons to do that. Let's just admit that keeping people in jail is a very, very expensive proposition, and local government should not have to, have that kind of a burden. The taxpayer shouldn't, that the whole evolution of that thought process and the morphing of that thought process has really been accepted by the public, very much so. When it was studied by the National Center of State Courts, 1,000 people were asked about their feeling about pretrial detention and whether, a lack of funds should keep you in jail. 77% of the people said no, that should not be your financial condition, you can't be jailed for being poor.
Yes.
Because somebody could be a heinous criminal and got the money and they're back out on the street. So there's no rhyme or reason to the whole thing. So we've implemented things at the rules in the court. So your first go-to is a trial judge when you're taking a look at someone in front of you is not cash bail. Is this person, why can't this person be of their own recognizance or conditions, etc.? You take a look if they're a frequent flyer where they've been before the court and they don't show up. Capiases have been issued, et cetera, et cetera. Well, that's a different thing because then you can do, some other guarantee or surety that they're going to be there. Most likely an ankle bracelet and continued monitoring, that sort of thing. Maybe, a monetary investment, but it doesn't have to be astronomical because money, doesn't grow on trees, and $100 bond for these folks, it might as well be $1,000 bond. That's just as important to them. So anyway, that kind of reform, I think, is embedded in our rules of a court, and now the legislature is entertaining a legislation that was introduced a couple of weeks ago to recognize, to codify these rules with regard to bail in our state, which is long overdue, very long overdue.
Is it a bipartisan issue?
It is. Oh, and these bills are supported, bipartisan support here. It's not a Republican, it's not a Democrat issue whatsoever. It's not soft on crime. Mm-hmm. It's an effort to be constitutional, and it's an effort to be fair, and it's an effort to not kind of desecrate the existence of that defendant. Because if it's a nonviolent offense and you just don't have the money, to post your bond, as I said earlier, 3 days in jail, you're going to lose your job. 4 days in jail, 5 days in jail, you're going to lose where you're living. You're going to lose your support system, maybe your girlfriend, maybe, your kids might have to go to, children's services. Your whole life is disrupted. And then if you do, when your case is resolved, what do you get? You get probation and you're out and about with conditions. But meanwhile, your life has been shattered, for the month that you've been sitting in jail. So,
isn't it a little ironic that in these days of hyper partisanship, that this seems to be an area in recent years where Republicans and Democrats have found some common ground? Wouldn't have expected that 20 years ago. Why do you think that is?
I think the perspective on the purpose of bail has changed, and there's been good argument for that. I think the court looking at it from the very first, the bail task force that I established a couple of years ago, mm-hmm. and I put everybody that was a interest group representative on that task force, so everybody got a voice. The report that came out about that was pretty comprehensive, and again, people started to think about it, and judges were thinking about it, and I think the light went on for a lot of people about, okay, wait a minute, what are we doing here? And then there's always, as I said earlier, the argument that we're burning money. We mm-hmm. might as well just take that money, put it out in the driveway and light it on fire, because it's not doing anybody any good when it's being spent on detaining nonviolent offenders in the county jail and all the expenses that are associated with that. And then, as I said, the devastation to the individual defendant and their lifestyle, their support system, etc. It's a lose-lose for everybody. And I think that's been embraced, and it's obvious. Now, getting to that reform legislatively, I'm not saying everybody's on the same page, mm-hmm. and we're going to see. One of the things that I didn't mention about how bail morphed in our country is it became an industry. We have bail bondsmen, and it is an industry, and it's no secret that the bail bondsmen are very much against bail reform.
Yes.
Their argument is that their livelihood is jeopardized. And yes, that's true. But, that's not a reason to consider, to continue with an unconstitutional industry.
But you can't underestimate the fact they could have some more influence in the legislature, even though they don't necessarily have influence in the judicial branch.
Well, yeah, any interest group will be listened to, rightfully
Right.
so.
Sure.
Rightfully so.
Just more than a year ago, we had the killing of George Floyd, and there's been much discussion about racial fairness in the criminal justice system. You've been involved in conviction reform, death penalty reform. Talk a little bit about that.
Yeah, a couple of years ago, we set up the death penalty task force, and again, more than a couple of years ago, I guess, and brought everybody, interested parties to the table about that. And there was a report that was issued about, the death penalty and what the recommendations were for the death penalty. The majority of those recommendations are statutory, changes. There was a majority report, and then there was a minority report or a dissenting report that came out, and that was mostly the prosecuting attorneys that were on the task force that didn't agree with the recommendations. So, as I said, there wasn't a kumbaya moment and everybody thought, we should end up at the same place. It was not a cohesive group with regards to the recommendations. But those recommendations are out there, and there is always talk every legislative session about doing away with the death penalty.
Yes.
And, some people think, the halfway mark, the compromise is life without parole. And that was going to diminish the use of the death penalty. It has not significantly. From our perspective, we still, we've always got these death penalty appeals that we're dealing with because, there's a lot of death penalty cases that are in the pipeline from the years. It takes a long time for a death penalty case to ripen and then come before the court and the hearings, etc. And then, it goes to the federal system subsequent to that. So there's still a lot of death penalty cases out there, although the life without parole, situation is increased in its usage as well. And I think that's the more comfortable thing for the public to hang on to, to appreciate and want to have is life without parole.
Mm-hmm.
Interesting. We see that as an alternative and maybe a more civilized response to taking the life of another human being. The defendant took the life of another human being, and we're not going to take their life as the government. We're going to do life without parole. A couple of years ago, I was in Ireland, and I was giving a presentation, and there was an Irish law professor with me, and the two of us, and that was the first time I heard that the European Union views life without parole almost as barbaric as taking somebody's life.
Interesting.
Yes, it's not an accepted practice in Europe and in Ireland. The life without parole, that's considered, as I said, almost as inhumane, as barbaric, as immoral as taking, performing an execution. Well,
I want to talk about one other issue, and then I want to talk about how you make your decisions. But the decision I would like you, the thing I'd like you to talk about a little bit is about grand juries, because it's a very misunderstood concept in American justice. People see it all the time on television, but they really don't understand grand juries. And you put together a grand jury, I think it was a task force to examine improvements in the system. Tell us a little bit about some of the improvements that you have initiated.
Well, again, these reports come out, and there's recommendations in the reports, and those reports, yes, there's procedures and policies that judges can embrace, but there's a lot of recommendations that have to be statutorily embraced. We know at this point the sanctity of the grand jury, and the testimony is secret. It's always a secret grand jury, and there's a lot of reasons for that. And one of them is that if someone's case is presented to the grand jury and it's no billed, in other words, they found that there's no reason to issue an indictment for this individual, then nobody should know that that person was a suspect or under suspicion for the commission of whatever the offense was. It could be a very egregious offense, or it could be, a lower level non-violent offense. But nobody should know that. Um, if the grand jury runs, appropriately. There are circumstances when a judge, and this was present before the grand jury task force, can release the grand jury testimony. There's circumstances, it can be used to impeach on occasion, and it can be, and the only time I can remember where a grand jury testimony was kind of revealed, I think Prosecutor McGinty did that.
Tim McGinty, yeah.
In Cuyahoga County, if I'm not mistaken, for the Tamir Rice.
Yes.
Yeah. And that was not widely viewed as a thing to do, a good thing to do. By other prosecutors, judges, lawyers, it was kind of, so I don't, first of all, grand juries are not going away, nor should they. I think that it's a valuable tool. I think that there are responsibilities for those that present to the grand jury, which are prosecutors. And, their witnesses are usually the police. And I think the prosecuting attorneys all have to realize that their oath of office that they agree to, they swear to, is to do justice. And so you've got to be fair when you're attempting to indict someone. And I know that, it's only probable cause at the grand jury. It's not the trial. And there's a lot of controversy over what you introduce at the grand jury. I think if I were doing my job as a prosecuting attorney now, as compared to when I was doing it, in the mid to late 90s, I would be a different kind of prosecuting attorney.
Really? How different?
Oh, yeah. I really think that I would be a different kind of prosecuting attorney.
In what way?
I was pretty reliant on the assistant prosecutors who, were handling these cases and taking them to the grand jury, because you're supposed to be. You got people that you trust. And I think that I can count on maybe one hand the number of cases that they brought to me and they said, okay, we're going to take this grand jury. And I said, no, not so fast. That's not, I don't think based on the evidence that I'm looking at that this person should be charged. The police have to get more evidence if there is more evidence out there. But this is, I'm not going to, authorize that you take it to the grand jury. Like I said, one hand that I probably could do that for, and there probably would be more at this point. I can truthfully say probably would have been more. But having said that, I know I was regarded as a fair prosecutor, by the defense bar of and prosecutors, defense bar judges. I didn't have any. I didn't feel like I was not doing my job according to how it should be done. But I'm older. I'm wiser. I've seen more things. It probably would be a different system. But getting back to the grand jury and whether transcripts should be out there in the public, I am not for a free-for-all release of transcripts just on a whim or just on an ask. There has to be a reason, because I do believe that part handled correctly, the grand jury handled correctly, is a valuable tool for both the prosecution and the defense. And keep in mind that a defendant can testify in the grand jury as well. So any exculpatory information can be brought in, if there is some, by the defendant.
There's a lot of other areas you've been involved in, but I want to shift the subject to something that is I think a secret to most of the public, and that is how the Supreme Court goes about making its decisions. What happens behind those closed doors? How much can you tell us?
Oh, well, it's short of telling you what the decisions are, I can tell you what the process is.
Good, go ahead.
We get. I always, akin to it. We get people knocking on our door. They want the Supreme Court to handle, review their case. Either it's a direct appeal, an original action. Those are, some of those cases we are mandated by Constitution to take. the death penalty straight from the trial court to the Supreme Court. PUCO, Public Utility Commission, we have that jurisdiction. Again, we take those workers' comp, taxation, and I know I'm forgetting another one, but those are appeals that we take, and we don't have really a choice. That's just mandated constitutionally. But then the ones that are discretionary, because we are declared to be a court of discretion. They have to be of great general or public interest. They have to affect more than just the people that are involved in the case. In other words, it's a bigger question of law. It's a bigger perspective. Or it might be the opportunity to interpret a statute that has never been interpreted before, or never been interpreted and applied to the set of facts that are, find themselves, before the court. Or there's a conflict. One appellate jurisdiction, rules one way on the same statute, and another one or another two or another three, rule the opposite way. And we have to settle those, district disputes and come up with, the law as it applies to that statute and its application. So we review what we call the calendar every 2 weeks. We've got a calendar that we have to review these cases on, jurisdictionals and other cases to wanting our attention. And they take 4 votes to agree that we are going to take it in, that we are going to hear this case, that we are going to instruct the parties about what propositions of law we have accepted, and they will then start on their briefing schedule. And the parties we have a certain timeline for the submission of your brief, your reply, then your rebuttal, and then we set it for oral argument. All right, so the case makes it to oral argument, and it's scheduled, and you get all the briefs and everything to read and prep for, and not just the briefs filed by the parties, but the briefs from amicus, which can sometimes, oftentimes, they're more to read there than the parties, because there's page limits, to the briefs.
Friends of the court, yeah. Mm-hmm.
Yeah. So anyway, we get the cases. You prepare for oral argument. Each justice prepares however they prepare, which is with their staff. And again, there's 7 justices. There's probably 7 different ways that people prepare for oral argument. But then we have oral argument, and the oral argument, each side gets 15 minutes to argue. Sometimes they're peppered with questions. Sometimes they're not, and they're just putting forth their arguments pretty straightforward. A death penalty case, you'll get an hour, a half hour for each side, and if you talk to anybody that's ever been before the court, they'll tell you it went like a blink of an eye. It was a really good experience, but it was extremely fast. And the good thing is that we archive all these arguments. So if you're good and bad, I guess, if you're one of the litigants and you then go to the archive and you see your performance, that could be a good thing or could be a bad thing, depending on, how you think you did. Most people are probably too critical of themselves. But anyway, you can view that. So, we get through oral argument. Immediately afterwards, we then conference, and it's the 7 justices and the court reporter, and we go around the room. I go first, and it goes by seniority, and we take case by case, and you say what your tentative vote is, your first vote, and why. And then that goes from the chief to the least senior. Then we open it up for discussion, because that first round, nobody can interrupt, and it's just a straightforward, uninterrupted presentation. And then there's a discussion. Anybody that wants to ask a question of another justice, what's your rationale here? Why do you think that? What's the And so discussion takes place, and then when everybody's had their say, we go in reverse order just to confirm what your vote is on this case. And you're reminded that this is always just tentative. You're
not bound by what you say.
Yeah. You're not. But what that is used for is to determine then who's going to write the majority opinion, and who then will, you look around and see who's agreed with you and are dissenting the case. And so those that are in the majority we all have little marbles with a number on it, and there's a little leather bottle, and those numbers the balls go in the bottle, shake it up, the first one rolls out, has to write the opinion. That opinion is assigned to them. And their name is on the line for that case. And we do an equal distribution of the cases. So say the next case comes up, we go through the same process, and it might be the same count, 4-3, and the person that just got a case is in the majority. Their marble doesn't go in the in the bottle, just so they're not eligible for that second case, just so the other, 3 can be involved in the role. And we do that just to keep an equal distribution of cases. There's no trading of opinions. Nobody says, hey, I'd rather write that. How about if you take this? That is forbidden. Will not happen. And then, the drafts are circulated, and, there's the ability to agree. There's an ability to offer edits. There's ability to take that draft and write a dissent, and then circulate that dissent. And sometimes the dissent is so persuasive, it takes somebody away from the majority, and the dissent then becomes the new majority, and the majority becomes the dissent. That happens on occasion as well. So, and then, it goes through editing, and we make sure that, everything is appropriately cited, and facts are all checked and all that sort of stuff. And then it's released. And
how long does that process usually take from beginning to end?
It depends on the case. It really does. Some justices struggle with writing the majority opinion, especially, if it's a truly close call. And, theoretically, we wouldn't take them if they weren't close calls, or, the law was unsettled, or et cetera. But, sometimes they struggle. We like to get, cases moving, and we monitor a timeline. And so it's all, we all know how cases are coming along. And there's nothing to stop you from, inquiring of another justice, are you going to include this? Are you going to, this argument, that sort of thing? Because that helps to speed things along. Because if you want something in the opinion, and the author of the opinion doesn't believe that it's a valid, point, and the other 3 justices don't either, et cetera, you can write a concurring opinion saying, I concur with the majority, but for different reasons. And, that happens. It's always preferable to have 4 solid votes that are going to go with the majority. If you've got a fractured opinion, that does, I think, very little good for the bench and the bar below. Very little good. I always, I try to get a consensus, and I'm willing to compromise points, arguments, include, exclude, in order to get as many signatures on that case as that opinion as we can, because I hear from appellate judges, what's with all the dissents? What's with that doesn't help us. These close calls, these fractured opinions. I don't think that that's the way to do this job.
How often do justices change each other's minds?
Oh, that happens. That happens a lot. It really does. Again, especially in these really close, and then sometimes what happens is that an obscure fact that is contained in the record that really wasn't hit on by either party in oral argument, and then the person and their staff that are writing, the opinion, they come up with something, and it's like, oh, wait a second, this happened in this case, and here's why. It's not the case we thought it was. And that happens, and it often, I should say, it does not happen often at all. But I think when it does, it happens when the people who are doing the appeal to the Supreme Court are not the people that had any involvement with the case below.
A whole nother perspective.
Their perspective and their grasp on the record might not be what it should be.
I see. Oh, okay. That's interesting. Have you ever had anybody who was assigned a majority opinion who came back to you and said, I can no longer take the majority side. You have to give it to somebody else?
Yes, we've had that happen. And there's a memo, circulated as to why that person thinks that now, this is the way to go. And if that person, if it's not going to change the vote, in other words, say we've got a 6-1 or we've got a 5-2, and it's not going to change the vote, that person will go into the dissent and we'll roll it with the 4 remaining justices to see who gets it. But if it changes the vote, then the dissenting view becomes the majority view, and that same justice will write that majority opinion. They're just writing it, from the opposite. They don't. They don't get get off that easy, just by saying, because you've been assigned it, and tell us why you think the dissent is now the better argument, and people might agree.
We're nearing the end of our interview, and the name of this podcast is not only Living Justice, but Living Leadership. We've talked a lot about justice, but I want to ask you and put you on the spot for a moment and ask you if there are 1 or 2 or even 3 leadership lessons that you have learned over your remarkable career in the private sector and the public sector in a variety of different offices that you can impart to those who are listening and watching today, many of whom are law students, some of whom are lawyers, and some of whom, by the way, are not involved in law at all. What are your thoughts?
Well, I mentioned it briefly earlier. Surround yourself with smart people, the smartest people you can get to do the job, and let them do the job. And, obviously keep abreast of what's going on. You don't just jettison folks, but become part of the team and make them feel valued, because they are valued. And, that makes a great work environment, and it really produces a great product, whether you're dealing with policy development or whether you're dealing with, opinions and drafting opinions, and because, I've always ascribed to that. I mentioned that when I was talking about the success of the Child Support Enforcement Agency in Summit County way back when. Get the right people in there, kind of get the wrong people out, and make sure that they know that they have the authority to do the right thing and use their judgment. And that goes not just for law and not just for being a judge. That goes for corporate. That goes for family businesses. That goes in every. Now the challenge is to try and make yourself, not me as the the justice or the prosecutor or whatever, but try and make yourself that valued employee that the leader wants to hire, because that's that will help. You have an improved career. You get to have more responsibility and do bigger and better things, and sort of that. So, look at the next job or the job that you want, or maybe the job that you have, through that lens. How can I make myself indispensable? How can I make myself, part of this team, so that, I'm relied on, and when another opportunity presents itself, maybe advancement, I don't know, they'll think of me. That's an important thing to do. And give everybody a fair shot is important. But I think it's also important when you realize that it's not working out, because there's nothing worse than somebody to be in a job and be miserable. They're miserable.
Right.
They're not doing a good job, and you have to recognize that. And oftentimes you just have to make that hard call, for the benefit of everybody involved, the institution, the product, and the morale. Extremely important to do that. You also have to realize, even if you're kind of at the top of the pecking order, don't make it about you, and that's a real challenging balance to maintain, because when you're running for political office,
it has to be about you to a certain extent.
Yeah, it is about you. So how do you do that balance? Because you wouldn't be you. Your success wouldn't be yours without this team.
Yeah.
So even when you're running for office, instead of saying it's the Maureen O'Connor show, it's the Chief Justice of the Supreme Court and staff that you're electing, ladies and gentlemen, and that's the better argument, I think, because, yeah, you can talk about yourself, forever, like I've just done for how many minutes here.
That's
But
because of mine. That's because I was asking you those questions, though.
right, but that's the balance, and I'll tell you, it's not easy as a politician. When you listen to other politicians talking, and you look at their attempts to get votes, they make it personal, and they make it all about them versus all about you.
Yes.
Your opponent, and people don't want to hear that. I mean, look what's going on in New York City with the races, for mayor in New York City. It's getting really personal, very much so. I hope Cleveland doesn't get like that. But that's my advice for people that are contemplating running for election. But keep in mind, you can be a public servant without being elected in an elected position. And I've chosen to use my law degree all these many years as a public servant. And I have never regretted it. The, financial, rewards are not the same as had I been, maybe in private practice in a different venue, different way. But I don't think I would have gotten the level of satisfaction because I look at the judiciary especially as me using my talents to help people who can't help themselves. They find themselves in a situation and they don't want to be there. They're, dragged into court, maybe in a civil action. They're arrested in a criminal action. They've got problems. And they can't solve those without the justice system. And so your obligation is to make that justice system as responsive and as problem solving as you can. And I like doing that. And I especially love doing that as a common pleas court judge, solving problems, for people. Same thing as a probate magistrate, etc. You're really, and I think every judge feels that you're helping people, and lawyers are in a helping business. That's what we're all about.
We've been talking for a long time, and we actually could go on much longer, but it wouldn't be fair to you, even though I think our listeners would like to hear you much more. So I want to thank you today for having spent so much time with us. You've had a remarkable career. There are many people who have served as judges who spent their whole life as judges. And while there's nothing wrong with that, I actually think that the best office holders and the best judges are those who've had varied life experiences, varied perspectives, and you certainly have had that. From prosecuting attorney to a common pleas judge to a lieutenant governor and director of the Department of Public Safety, a justice, and then the chief justice, and you left quite a legacy. I, for one, am opposed to mandatory retirement. I don't think it makes any sense whatsoever, and I hope someday we abolish it. But bottom line is, I hope that whatever you do after you eventually have to retire, unless we can change that, and I'd love to, that you'll continue some form of public service because you're much too young not
Absolutely.
to continue some form of public service going on. And even though we're the same age, you look much younger and you've got a great career ahead of you. So whatever you do next, I hope it's equivalent in some ways to being the Chief Justice of the Ohio Supreme Court. So thank you very much, Chief Justice Maureen O'Connor, for spending so much time with us today.
Thank you. It was a pleasure.
Thank you.